Welcome back, dear students. Today we will learn and understand the scope of right to privacy under our constitution. What is privacy? According to Black's Law Dictionary, privacy means right to be let alone or the right of a person to be free from any unwarranted publicity or the right to live without any unwarranted interference by the public in matters with which public is not necessarily concerned. Dear students, you must have read this Black's Law Dictionary, very good dictionary, while defining the legal terms. So far as our constitution is concerned, the right to privacy is a part of right to protection of life and personal liberty, as we have read in Article 21. And Supreme Court has said that privacy is a fundamental right. Privacy subserves those eternal values upon which the guarantee of life, liberty, and freedom are founded. It includes internet privacy also. If I am working on internet, then nobody should have access to my email or my WhatsApp or my Facebook account. So this privacy includes internet privacy also. If we compare the legal position from United States, in USA, they have Privacy Act 1974, a federal law which establishes a code of fair information practices that governs the collection, maintenance, use, and dissemination of personally identifiable information about individuals that is maintained in system of records by federal agencies. In India, we have Article 21. Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. After reading the Article 21, it has been interpreted that the term life includes all those aspects of life which go to make a man's life meaningful, complete, and worth living. And this right to life also includes right to privacy also. Supreme Court has implied the right of privacy from Article 21 by interpreting it in conformity with Article 12 of the Universal Declaration on Human Rights and Article 17 of International Covenant on Civil and Political Rights, 1966. Both these international documents provide right of privacy. And since India is party to these two international conventions, so right to privacy is now interpreted as part of right to life under Article 21 and for respecting these two international covenants also. Then, dear students, Indian legislature tried to pass a privacy bill in 2011, which is in a condition of bill till date. It has not been passed by the parliament. The draft privacy bill of 2011, this bill seeks to provide privacy to all citizens and provides penal consequences for its violation also. If somebody is violating my privacy, then it becomes a criminal offense. And this act, this bill rather, because it is not yet passed by the parliament, this bill says that every individual shall have a right to his privacy, confidentiality of communication made to or by him, including his personal correspondences, telephone conversations, telephone messages, postal electronic mails, and other modes of communication, confidentiality of his private or family life, protection of his honor, good name, protection from search, detention, or exposure of lawful communication between and amongst the individuals. This bill also protects privacy from surveillance, confidentiality of his banking and financial transactions, medical and legal informations, and protection of data relating to individual. Thereafter, we had a data protection bill in 2018 also, which is yet to be passed by the parliament. So far as right to privacy is concerned, for the first time, Supreme Court in Khadak Singh versus State of UP acknowledged this right to privacy. And it was held that right to privacy could be implied from existing fundamental rights given in Article 19(1)(d), 19(1)(e), and 21. In this case, the UP Police Regulations, Regulation number 236B, permitted the police officers to visit to the residences of known criminals in order to make it sure whether they are at home or they had gone out for committing some offenses. So police was authorized to make domiciliary visits during night at the residences of the known criminals. Supreme Court said that this surveillance in the midnight affects my privacy, it affects my right to life. So these provisions, these regulations were struck down by the Supreme Court as violative of Article 21 because those regulations were without any statutory basis. You can make rule and regulation if it is authorized by some law, and if it has no statutory basis, it is against the concept of rule of law. You cannot enact a rule or regulation which has no backing of law. So UP Police Regulation, which permitted domiciliary visits to the police at the places of known criminals, since those regulations were without any statutory basis, so they were declared unconstitutional by the Supreme Court. Because a criminal too has a right of privacy. He has a right to sleep, at least with his family in the midnight. How can you disturb him in the midnight when he is sleeping at home? He is not committing any offense. Maybe that 4 or 5 trials are pending against him. That is a different issue. But you cannot disturb my privacy in the midnight. In this case, Khadak Singh's case, Justice Subba Rao's minority opinion paved the way for later elaborations on the right to privacy under Article 21. Justice Rao said that the right to personal liberty takes in not only a right to be free from restrictions placed on his movements, but also free from encroachments on his private life. It is true that our Constitution does not expressly declare a right to privacy as a fundamental right, but the said right is an essential ingredient of personal liberty. The strong language used by Honorable Justice Subba Rao has paved the way to make right to privacy as a fundamental right in the present days. Then, dear students, we have a very important telephone tapping case, R.M. Malkhani versus State of Maharashtra. If I am talking to someone on mobile, nobody has a right to intercept and record it. It is my privacy. Why you will record my conversation? So Supreme Court in this case held that the telephonic conversation of an innocent citizen will be protected by the courts against wrongful or high-handed interference by taping the conversation. And the protection is not for the guilty citizens against the efforts of the police to vindicate the law and order or to prevent corruption of public servants. Telephone taping actually is permissible in India under Section 5, Clause 2 of Telegraph Act 1885. But the section lays down certain circumstances and grounds when an order for tapping of a telephone may be passed. But no procedure for making the order is laid down even under Section 5, Clause 2 of Telegraph Act 1885. So if you are tapping my telephone, recording my telephone conversation without any justification, It is against the law. It affects my privacy. It affects my right to life and liberty under Article 21. We have another case, Govind versus State of Madhya Pradesh, wherein Supreme Court took a more elaborate appraisal of right to privacy. The court was evaluating the constitutional validity of regulation number 855 and 856 of MP police regulations, which provided for police surveillance of habitual offenders, including domiciliary visits and picketing of the suspects. Supreme Court desisted from striking down these invasive provisions because they had a statutory basis. In Khadak Singh's case, the regulation number 236B of UP police regulation, I'm going back, was without statutory basis. But here in Madhya Pradesh, the regulation number 855 and 856, which were authorizing same domiciliary visits as in UP, but here in MP, these regulations were framed under a proper legislation. So they had a statutory basis. So Supreme Court protected these domiciliary visits in Madhya Pradesh, whereas they were struck down in UP because in UP, those regulations were made without any legal basis. It was held in this case that it cannot be said that surveillance by domiciliary visit would always be an unreasonable restriction upon the right of privacy. It is only persons who are suspected to be habitual criminals and those who are determined to lead a criminal life that is subject to surveillance. Supreme Court says that this surveillance or domiciliary visits are not always unreasonable. They may be reasonable in cases of habitual criminals. So court accepted a limited fundamental right to privacy as emanating from Article 19(1)(a), 19(1)(d) and Article 21. You have a fundamental right, but not an absolute one, not in all the cases. Then we have another important case, R. Rajgopalan versus State of Tamil Nadu. In this case, the right to privacy of citizens was dealt with by the Supreme Court in following words. See the words used by the Supreme Court. The right to privacy is implicit in the right to life and liberty granted to the citizens of this country by Article 21. It is a right to be let alone. Mujhe akela rehne do. Don't disturb me. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. All these things are included in my privacy. I have my own privacy. I have privacy of my family, privacy of my marriage, privacy of procreation of children, privacy of motherhood, privacy of childbearing, and privacy of education also. None can publish anything concerning these matters without my consent, whether truthful or otherwise, and whether laudatory or critical. You will have to take my permission because it is my fundamental right to privacy. Then we have on telephonic conversation another case, PUCL versus Union of India, where the Supreme Court observed that we have no hesitation in holding that right to privacy is a part of right to life and personal liberty enshrined under Article 21 of the Constitution. Once the facts in a given case constitute a right to privacy, Article 21 is attracted. The said right cannot be curtailed except according to procedure established by law. It was held that right to privacy includes telephonic conversations also. If I am talking to someone, it is my privacy. Then, dear students, if I am suffering from a dreadful disease and a girl is going to marry me, she wants the doctor to disclose what ailment I have. And I'm saying that it is my privacy that you will not disclose my illness to my would-be wife. So Supreme Court says no. Disclosure of dreadful disease is not part of privacy of the patient. The leading case is Mr. X versus Hospital Z. The question before Supreme Court was whether the disclosure by the doctor that his patient who was to get married had tested HIV positive would be violative of patient's right to privacy. Supreme Court said no. Supreme Court ruled that right to privacy was not absolute and might be lawfully restricted for prevention of the crime, disorder, protection of health or morals, or protection of rights and freedoms of others also. If patient has a right to privacy, that his disease should not be disclosed to his prospective wife, then prospective wife also has a right to know the ailment with which I am suffering because she is going to marry me. So it was held in this case that HIV positive person does not have a right to privacy against the doctor not to disclose his status of the disease. So doctor is bound to disclose to the girl that, well, the boy to whom you are going to marry is admitted in our hospital and he is found HIV positive. The patient does not have right to privacy in such cases because here the right of other persons is also involved. Then we have Sharda versus Dharampal, another case in which Supreme Court ruled that a matrimonial court has power to direct the parties to divorce proceedings on the ground of unsoundness of mind or impotency, etc., to undergo a medical examination. Suppose my wife has filed a divorce petition against me that I am of unsound mind or I am impotent. Now court directs me to undergo medical examination so that the ground of divorce, unsoundness of mind and impotency may be tested and proved with the help of expert doctors. And I say no, it is my privacy that I will not go for medical examination whether I am impotent or not, whether I am of unsound mind or not. Supreme Court says that this could not be held to be violative of one's right to privacy. Privacy is there, but now the question before the court is whether I am impotent, whether I am of unsound mind or not. So I will have to go to the doctor. I will have to obey the direction of the court, and it cannot be held to be violative of my right to privacy. Privacy is there, but not in absolute terms. I will have to go to the doctor and get myself examined whether I am impotent or not, whether I am unsound mind or not. And then, dear students, finally, this right to privacy was again recognized in Justice K.S. Puttaswamy versus Union of India in 2017 by the Supreme Court, where Supreme Court declared that right to privacy is a fundamental right protected under Part 3rd of Constitution of India, while primarily focused on individuals' right against state for violation of their privacy. State cannot violate my privacy rights. Then, dear students, this privacy extends to the limit of women's right to make reproductive choices. Woman wants to have a baby girl. She doesn't want a baby boy. She wants a testing whether she is going to deliver a male or female child. You know, this is prohibited in our country. But a woman's right to make reproductive choices includes women's right to refuse participation in sexual activity, or alternatively, the insistence on the use of contraceptive methods, such as undergoing sterilization procedures, women's entitlement to carry a pregnancy to its full term, to give birth and subsequently raise the children, all are part of right of privacy of the woman. She has right to make reproductive choices. You cannot compel a woman all the time to have sex with you, to produce babies all the time for you. So that is also part of privacy of the women, which is part of her life and personal liberty under Article 21 of Constitution of India. So dear students, this is all about right to privacy under Indian Constitution. Thank you very much. God bless you.